It is my pleasure to introduce our keynote speaker, Brenda Gotanda. Brenda is a partner with Manko, Gold, Katcher, and Fox LLP and brings over 30 years of experience in environmental regulatory compliance, enforcement, and transactional matters. Clients across a wide range of industries rely on her expertise to navigate complex environmental challenges, manage risk, engage with regulators, and achieve their strategic goals. Her work spans environmental and energy law, including permitting, enforcement actions, site remediation, project development, and regulatory compliance. She has advised clients in sectors such as manufacturing, real estate, energy, telecommunications, transportation, waste management, and retail. Brenda has handled significant matters involving wastewater and stormwater NPDES permitting and enforcement, TMDLs, waste and chemical regulations, PFAS, brownfields and former defense sites, spill prevention and emergency response, Superfund issues, due diligence in real estate transactions, and occupational health and safety. So please welcome me in welcoming our keynote speaker, Brenda Gotanda.
All right. Thank you, Kaisen. Aloha and good morning. Thank you all for joining us today, and thank you to the Hawaii Department of Transportation for inviting me here to talk with you a little bit about construction, stormwater law, and permitting. It's an honor to serve as your keynote speaker. As Kaisen said, my name is Brenda Gotanda, and I'm a partner with the environmental and energy law firm of Manko, Gold, Katcher, and Fox. I've been practicing environmental law for over 30 years now, working with clients on matters involving water, waste, and chemical substances, often in the context of permitting, compliance and enforcement, spill response, site remediation, and transactions. So my work involves helping clients to understand the law, comply with the law and their permits, and when something gets off course, something goes wrong, I help them to get back on track and into compliance, and as needed, to represent, defend them in agency enforcement actions. So my presentation today weaves together both legal concepts and practical experience. And today I'm going to help you understand what you need to know about construction, stormwater law, and permitting. Okay. Now, to be clear, I'm not here to make you all into lawyers, so don't worry about that, but just to help you understand the basic concepts and how to avoid some of the common pitfalls, so that hopefully you won't need a lawyer, or you'll at least recognize when you do. So these are the topics that I'm going to cover with you today. I'm going to start with the Clean Water Act, talk a little bit about NPDES permits, state delegation, BMP SWIPs in controlling site runoff, enforcement, some common non-compliance issues, and some recent legal developments. So we start with the Clean Water Act, and that's because the Clean Water Act is the key federal statute that protects water from pollution and it regulates water quality. So its primary goal is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. But the Clean Water Act also contains other key goals as well. You may have heard of the fishable, swimmable goal. The Clean Water Act says that it's the national goal that wherever attainable, an interim goal of water quality which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water be achieved by July 1st, 1983. So the modern Clean Water Act was created in 1972 through amendments to an earlier federal water law called the 1948 Federal Water Pollution Control Act, which, quite frankly, was not very effective. So the 1972 Clean Water Act created a new regulatory framework for managing the nation's waterways. And to accomplish its goals, it has two key elements. Number one, a prohibition, and number two, a permit system. First, the prohibition. No polluting without a permit. The Clean Water Act prohibits the discharge of any pollutant from a point source into navigable waters without a permit. Pretty straightforward. However, those terms that I've underlined on the slide, they all have unique definitions that have been interpreted and reinterpreted again by courts in litigation and by the agencies like EPA in policy and regulation. And they continue to change and to evolve, and we'll talk a little bit more about that. But briefly, here's what you need to know about those terms, okay? Pollutant. It's very broadly defined, and it covers almost any kind of contaminant that you can think of, from waste to garbage to sewage and sewage sludge to chemicals, biological material, radioactive material, dredge spoils, wrecked equipment, all sorts of things, as well as things that you might think of as just natural. So rock, sand, dirt, and heat. Those are all within the scope of that definition. Okay, next. The prohibited discharge is one that is from what's called a point source. And that means any discernible, confined, and discrete conveyance from which pollutants are or may be discharged. So like this picture here of the pipe on the slide, that's one type of point source, a pipe. It could be any type of a pipe or a ditch or a trench or a channel, even a container, a drain, a well, or a vessel, so fairly broad. And the discharge must be one that is into navigable water to fall within the prohibition. Now, I don't have a picture on the slide of a canoe or a ship. I have a waterfall. And that's because the water doesn't actually have to be capable of use for navigation. It's defined as waters of the United States, and sometimes people just call it WOTUS for short. You may hear that. But it includes things like rivers, streams, lakes, and oceans, and also wetlands. And there's been significant litigation over the years with regard to this definition of WOTUS, or waters of the United States, and whether it extends to different types of wetlands or different types of streams that are sometimes dry. And each new administration seems to take a different position. In fact, EPA just proposed a new definition this past week. They announced it, I think, on Monday or Tuesday, and it showed up in the Federal Register yesterday. So it is continuing to evolve. We are not going to dive into those muddy waters here today. Just know that under current federal law, it generally refers to relatively permanent, standing or continuously flowing bodies of water that form features like rivers, lakes, streams, oceans, and then adjacent wetlands that are indistinguishable from those bodies of water due to a continuous surface connection. So that's sort of the current state of the law. And finally, discharge means any addition of a pollutant into navigable waters from a point source. And all those elements need to be present for the discharge to fall within the scope of that prohibition. Okay, so now that you understand the prohibition, let's turn to the permit system. Okay, so the Clean Water Act established a permit system called the National Pollutant Discharge Elimination System, NPDES, or some people say NPDES. And a NPDES permit, it gives you permission, it allows you to discharge, but it is a privilege and it is subject to terms and conditions. So the permittee, the holder of the permit, is allowed to discharge provided that it complies with the conditions of the permit. And those conditions will often be things like limits on the type and amount of pollutants, as well as other types of requirements like sampling and monitoring, O&M and housekeeping, inspections, record keeping and reporting, and then other types of requirements that are necessary to protect the water quality in the receiving water. So I tell you, it's very important to read that permit when you get it. It is it's important not to just to toss it in the drawer, because I tell you, some people do that to their detriment. But it's important to read it, to understand it, and to comply with it. for a few reasons. Obviously, you need to comply with it so that you're not on the back end of an agency enforcement action. But maybe even more importantly, in order to avail yourself of what's called the permit shield, you need to be in compliance with that permit. And the permit shield is a legal defense, and it protects the permittee from liability under the Clean Water Act. And it states, the Clean Water Act states, that compliance with the permit is deemed compliance with the Clean Water Act. So somebody can't come along later and say you should have been doing something different and bring a suit against you, provided that you comply with that permit. And you know, there are some limitations on that, but on the whole, it's really important, this type of defense. Okay, so NPDES permits, they can last up to 5 years. You need to timely apply for renewal. Again, just a little tip, there are deadlines in those permits for when you need to apply. And if you apply on time, but the agency takes too long to get that permit out, it's often administratively continued. So again, important to make sure that you timely apply for renewal if you need it. Okay, so there are two types of NPDES permits, individual and general. Let's start with the individual permits, okay? This is what you might think of as a traditional permit. And you have one permit that is specific to your operation, your facility, your discharge, and it's one permit issued to one permittee. So it's kind of customizable, meaning that it can have conditions that are specific to your activity, your discharge. And to obtain one of these, you need to fill out a pretty detailed individual permit application and submit it to the agency. The agency then prepares a draft permit. It provides public notice and a 30-day comment period before that permit's finalized. Now, another little tip, if this is your permit, use this period to read and understand that draft permit and to submit comments if there's anything in there that's incorrect, objectionable, or you're simply not going to be able to comply with it for one reason or another. It's really important that you do this before the permit is finalized because it becomes much more difficult to get it changed after the fact. Okay, now let's turn to general permits. Now this can be a quicker and more streamlined process than an individual permit. It's like a generic permit for a specific category of activities or discharges, so it can cover many permittees, but it's uniform for everyone. It's not customizable. So if you have an activity for which a general permit's available and you're able to meet those standard conditions and requirements, then you can apply for that. And you do that by submitting a notice of intent to seek coverage. And if it's approved, the agency will send you a notice of general permit coverage. Now, this notice is not your permit. This is just an acknowledgement that you're covered. In order to understand the terms and conditions, you need to go to the general permit itself, which is typically found either in agency regulations or some other documentation. Here in Hawaii, you can find it at the Department of Health regulations at HAR 1155. Now, general permits and individual permits are both subject to the same substantive water quality control protections, but they may be expressed in different forms. Okay, so here I just have some examples to show you of the types of discharges and activities that may be covered by a general permit. I'm not going to read them all. You can take a look at them, but they include things, for example, like stormwater associated with construction activities, the things that we're talking about here today. Stormwater associated with industrial activities, construction activity dewatering, and some other types of activities. So there are options to choose from, and you may apply for more than one if you need to. Okay, so how does stormwater fit into the NPDES program that we've been talking about? Well, let's look at a construction site example. Rainy day, rain falls to the ground on that construction site. As it moves across the surface, it picks up pollutants as it goes, and then it carries them into a storm drain or a channel or, some other feature, your point source like we were talking about before, that can flow into nearby waterways without any treatment. And so that's the problem that the program is trying to address. And the Clean Water Act requires that you get an NPDES permit for stormwater discharges from certain types of construction sites. In particular, a permit's required if your project causes a land disturbance of 1 acre or more, or if it's less than an acre, but it's part of a common plan of development or sale that ultimately, collectively, will disturb 1 acre or more. And in Hawaii, land disturbance is defined as any penetration, turning, or moving of the soil, or resurfacing of pavement with exposure of the base course or the bare soil or the ground surface below. So important to understand that we're talking about things like clearing, grading, excavating. It doesn't include just cutting weeds or cutting grass, cutting weeds, but if you're grubbing, right, and you're kind of pulling up the roots of that vegetation, you're disturbing the soil, then that does get covered. Now, Department of Health guidance also makes clear that not being required to obtain a permit pursuant to that framework doesn't necessarily protect you from an enforcement action if your project or activity nonetheless ends up causing water quality issues or violates other state water pollution control laws. So definitely something to keep in mind. Oh, wait a second. I wanted to touch on, too, some of the common pollutants before we turn that slide. Some of the common pollutants that are associated with a construction site. You can see sediment, soil, those things that we were talking about, solid waste, pesticides, oil and grease, debris, nitrogen and phosphorus. So those are some of the issues of concern at construction sites. All right, now let's look briefly at another specific type of discharge that requires an NPDES permit. These are municipal separate storm sewer systems, commonly called MS4, much easier to say that way. And these are publicly owned systems that collect and convey stormwater and discharge to surface waters. So, the components may be some of the things that we've talked about already. Storm drains, pipes, ditches, swales. And an MS4 is a specific type of NPDES permit that authorizes government entities to discharge stormwater collected by their MS4 systems. Now, EPA phased in this program over time, starting with the large and medium systems in phase 1, and then bringing the smaller systems in phase 2. And those phase 2 systems include not only the systems in smaller cities and towns, but also those on military bases and public universities, and, relevant to today, those that are managed by state highway agencies. And these MS4 permits require the permittee to develop a stormwater management program with 6 minimum control measures. And those are shown on the slide here. You can see that. Public education and outreach, public involvement and participation, detecting and eliminating illicit discharges, construction and post-construction runoff control, and good housekeeping. All right, so EPA is responsible for this NPDES permit program under the Clean Water Act, but it can delegate authority to the states to administer the federal program and to issue those NPDES permits. So this is important to understand. The state has to agree to implement a program that's no less stringent than the EPA program. They can request delegation for one or more components of the program, and EPA needs to review and approve their program in advance of that delegation. The states may also have their own laws, their own water quality protection, pollution prevention laws, and they may incorporate those state requirements into their NPDES program. And EPA has, in fact, delegated authority to most states, including to Hawaii, and it's delegated the Hawaii Department of Health Clean Water Branch administers the NPDES program in Hawaii, and the program does include state water pollution control requirements. Now let's look just briefly at Hawaii's delegated program. It's similar to that federal program, but uses a little bit different language and terms. We're not going to dive too deeply here, but just look at their pollutant prohibition. And that pollutant prohibition is found in the statutes, HRS 342D, and it prohibits the discharge of any water pollutant into state waters, except in compliance with state law or permit. So water pollutant, like the federal definition of pollutant, is very, very broad. And in fact, it specifically calls out in its list of contaminants things like soil and sediment, among other things. So again, important when you're talking about construction sites. Now, state waters, that term is the counterpoint to the navigable waters under the federal program, and that includes all waters within and around the state. But it is a little bit broader than navigable waters in that it includes groundwater. And that's pretty common for state programs because a lot of the states are the ones that have kind of primary authority over groundwater. Okay, now let's turn briefly to BMPs, SWIPs, and controlling site runoff. And I'm going to use the construction stormwater general permit as an example, just to focus on some key elements and orient you to it. There are 3 key categories of requirements, and those are shown on the far left-hand side of the slide. First are standard NPDES general conditions. So those are incorporated into the general permit. I've called out only one of those, and that one requires that you do not cause or contribute to a violation of state water quality criteria. This is a pretty broad catch-all, and this type of requirement was actually challenged as being overly broad in a recent federal case, which we'll discuss later. For now, just something to keep in mind. Next, erosion and sediment controls. You may know that by ENS controls. The permittee is required to design, install, and maintain ENS controls that minimize the discharge of pollutants from the earth-disturbing activities at the site. And we're talking about sediment, debris, other pollutants, the types that we've already discussed. And these are often referred to as best management practices or BMPs. And some examples of BMPs would be like, I have a picture up there of a construction site entrance and exit, sort of stabilization and track out controls. That would be one example of a BMP. And here, let's just jump into this slide. These are photos from HDOT's Construction BMP Field Manual. And they show things like silt fencing, perimeter controls, storm drain, inlet protection, concrete truck washout controls, dust controls, and stockpile protection. All right, and then back to the third element here. Another key element of the permit is the SWIP, that is the Stormwater Pollution Prevention Plan. And that is a site-specific plan that's developed to identify potential sources of stormwater pollution at the site, to describe the controls that are used to reduce or to eliminate pollutants in the site discharge, and to identify the procedures that are going to be implemented in order to comply with the permit. And the required contents of the SWIP are set forth in the general permit. So again, important to read the requirements of the permit. The slide here over on the right-hand side also shows some other key elements of the general permit, like notice of intent, site inspection, corrective action, reporting requirements. Okay, now let's move on to enforcement. Here we're going to focus on what happens when a violation occurs. Okay, so this could be a permit violation, or it could be failure to obtain a permit when one is required by the Clean Water Act. And there are a number of different ways that EPA can proceed with enforcement. I've listed 4 up there in the blue circle. We'll start with civil, administrative, or judicial enforcement actions. And EPA can choose which way it wants to proceed. If it chooses to pursue administrative action, it can issue an order to comply with requirements, it can assess penalties, could even revoke the permit if it feels like the situation warrants it. If EPA chooses to proceed with a judicial action, it can file an action in federal district court and seek penalties or an injunction, a court ordering the party to do something or to refrain from doing something, stop the discharge. And typically what will happen is EPA will send the alleged violator a notice of proposed enforcement action and an opportunity to respond and to discuss settlement. This is a key opportunity, okay, to correct the facts or the application of the law and to seek settlement. So again, you should, if you receive one of these, you really need to take a hard look at it. And what is it that they're saying the violation was? Do they have the facts to support it? Does the law support it? Or if not, meet with them, get it corrected, try to reach a settlement. EPA will hold a lot of the cards. If it feels like settlement negotiations aren't productive, it can also just, threaten to go into court. So it's important to defend your rights, but also understand that, reaching a settlement may be the best path forward in terms of resolving the violations. Okay, so there's also potential for criminal enforcement under the Clean Water Act for certain types of violations. EPA guidance currently recommends criminal enforcement in situations where there's significant environmental harm and really culpable conduct. So something that's deliberate or reckless, but you should be aware that the Clean Water Act also allows for criminal enforcement using lesser standards, like even negligence. Okay. EPA's Clean Water Act Enforcement Authority also can be delegated to the states as part of that NPDES delegation, but EPA retains authority to enforce if the states don't take enforcement action, and in some cases EPA will just take the lead if the state chooses to have them take the lead. Finally, citizen suits, okay? When the government fails to take action, the Clean Water Act authorizes citizen suits to enforce the Clean Water Act. And the citizens can sue a discharger as an alleged violator for a violation of the Clean Water Act or of their permit. Now, before filing this suit, they do have to give 60 days notice to EPA, to the state, and to the alleged violator. And this notice serves a couple of important purposes. Number one, it allows the state or EPA to step in obviating the need for a citizen to do that. And secondly, it really gives the violator, the alleged violator, an opportunity to comply. Another point to know, citizens do need to have standing in order to bring one of these suits, and won't get too deep into that, but they really have to have a sufficient interest in the matter. So the violation must have caused them an actual injury that can be redressed. Okay. All right, now let's talk dollars and cents. Okay, the Clean Water Act authorizes civil penalties for NPDES violations up to $68,445 per day per violation. Okay, so that's today's price. This amount is increased annually for inflation, so this is the amount that was set this past January. And as I said, the penalty amount is calculated per day per violation. So if a violation continues, say, for 100 days, you've got 68,000 times 100. It can add up to well over 6.8 million pretty quickly. So it is always important to correct those violations as soon as possible and try to stop the clock on this. Now, this is the maximum penalty amount, and the agency won't necessarily always assess for the maximum amount. The agencies and the courts, they will consider a number of different factors in calculating that penalty amount. And this is really important because your actions may help to reduce a penalty, or quite frankly, it could exacerbate it. But this is why I titled the slide Dollars and Cents, because using good sense can reduce those penalties. Now, the factors that are considered in calculating a civil administrative penalty include those things that are listed on the slide, things like the nature, circumstance, extent, and gravity of the violation, prior history, are you a repeat violator or not, degree of culpability, ability to pay, any economic benefit to the violator from that violation, and then there's a catch-all for other matters as justice may require. So, for example, the ability to show that you promptly corrected a violation rather than just let it go may result in the application of a discount in that penalty calculation. And EPA has published several penalty policies that walk through these factors in detail. They walk through the calculation, and these should always be consulted if you are negotiating settlement of an alleged violation, because they help you to understand what's going into this calculation and the ability to explain to the agency why perhaps it should be calculated differently based on the factors that are considered. And they address things like how long did it take to return to compliance? Was there any potential or actual harm? And what economic benefit you may have gained from a violation. And as previously mentioned, Hawaii has been delegated authority from EPA to administer the NPDES program, and Hawaii law does authorize civil penalties of up to $60,000 per day per violation. So my reaction is this is the one case, maybe, where things are a little bit cheaper here in Hawaii, but not by much. Then those penalties can still add up pretty quickly. So this slide is just news of a recent DOH enforcement action where the penalty amount was $2.4 million for allegedly discharging pollutants, including soil and construction materials, into a wetland, which are state waters, without a permit for 120 days. Okay, next, let's review some of the common types of construction stormwater non-compliance. You want to try to avoid these pitfalls if you can in your operations. First, failure to get a permit when one is required, pretty self-explanatory. Next, violation of permit conditions such as not having your SWIP or having an inadequate one or failing to properly implement it. Failure to implement or maintain BMPs, not having stabilized site, not conducting or documenting inspections, failure to file a notice of termination, and then the yellow box, I'm not going to go through it, but it provides a bit more detail on some of the common problems that get cited for BMPs that can lead to penalties. And then likewise, pollutant discharge or improper waste management can also lead to penalties. So that is just a quick overview of some of the common pitfalls that you want to avoid. Next, I want to just briefly touch on some noteworthy Clean Water Act cases and some legal developments. We're going to start with the County of Maui versus Hawaii Wildlife Fund. This is an important U.S. Supreme Court case from a few years ago. It is not a stormwater case, but it's still important because it changed the standard for when a discharge into a navigable water requires a permit. In that case, the Supreme Court ruled that an NPDES permit is required either when there is a direct discharge of pollutants from that point source, that pipe, into the navigable waters, or where there is what it termed the functional equivalent of a direct discharge. And in this case, Maui County discharged its treated wastewater into groundwater via injection well, and it traveled through that groundwater before emerging in the ocean via some seeps. And Maui County argued that this is not a discharge into navigable waters, but a discharge into groundwater, which is not a water of the United States. The Supreme Court disagreed and ruled that the permit requirement applies if, in fact, it is the functional equivalent of a direct discharge. And the Supreme Court identified a list of factors that should be considered in determining whether it is the functional equivalent, and those are listed on the right-hand side of the slide. You can see that it includes things like transit time and distance traveled to that navigable water, the nature of the material through which it travels, the degree to which the pollutants maintain their specific identity, and some other things. So the case was then remanded back down to the district court to evaluate the facts in light of these factors from the Supreme Court decision. And after considering those facts, the district court ruled that the discharge was the functional equivalent of a direct discharge and that Maui County was required to obtain an NPDES permit. I have to tell you, there are significant and complex ripple effects from this ruling across the country as it impacts the NPDES program. Hawaii in particular has many injection wells and subsurface type of discharges. In getting them all NPDES permitted, it seems like it may be overwhelming for DOH. I did read earlier this year that DOH was trying to work on a general permit for functional equivalent type discharges, while they're also working on individual permits for Maui County and some others. So this is an important case for you to know about. Another noteworthy case from the Supreme Court, which was issued earlier this year, is San Francisco versus EPA. And in this case, San Francisco challenged a requirement in its NPDES permit that prohibited any discharge that contributes to a violation of water quality standards in the receiving water. The Supreme Court agreed, and they ruled that NPDES permits can't condition compliance on the receiving water body achieving what they termed an end result. They said an NPDES permit has to be specific about what the permittee must do or must refrain from doing, and EPA has to determine what's necessary to protect the water quality in that receiving water body, not make the permittee responsible for overall water quality. EPA has modified its construction stormwater general permit to comply with this ruling. Okay. And this last case is from the Ninth Circuit Court of Appeals, issued last year. This is the Federal Appeals Court for the region that includes Hawaii. You can see the map up here on the right-hand side of the slide that shows what's covered by the Ninth Circuit. In this case, Puget Soundkeeper versus Port of Tacoma, the citizens group had brought a citizen's suit accusing the port and its terminal operator of violating various terms of its NPDES permit. And its issue was whether the permit requirements, that is the preparation of a SWIP and some sampling monitoring requirements, applied to the entire terminal or just to a portion of the terminal that was required to have an NPDES permit pursuant to the federal regulations. So the state issued NPDES stormwater general permit that was held by the port required stormwater controls across the entire facility. But the federal regulations only required stormwater controls in a portion of the facility, that is transportation facilities that house vehicle maintenance shops, equipment cleaning operations, or airport de-icing operations. The Ninth Circuit ruled that the citizen's suit under the Clean Water Act can be used to enforce requirements in state-issued NPDES permits that are broader than the federal law. Here are the state-based requirements. And this ruling would also apply in Hawaii, since Hawaii is within the Ninth Circuit. Okay. So that wraps it up. We've really covered quite a lot today in a short amount of time, but I hope that the information was helpful to you and you've picked up some useful takeaways. I want to thank you all for your attention, and thank you to the Hawaii Department of Transportation for having me here today. It's been a pleasure speaking with you, and if you have any questions or want to reach me, my contact information is on the slide. So thank you very much.